Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Malaysian Citizenship for Children Born Overseas. My name is Rachel Ng. I'm a paralegal with Wong and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Wong and Associates is a mid-sized law firm that was founded in 1985 by Datuk Mah Wing Kwai. Our able team today comprises of 22 lawyers and a support team of 19. Datuk Mah today is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation, details of which will be given at the end of this talk. We have two speakers for today, Ms. Jasmine Wong and Mr. Eric Toh. Jasmine will be speaking first, followed by Eric. We will then conclude with the Q&A session. Allow me to introduce Jasmine. She is a senior associate in our dispute resolution, employment law and industrial relations, and individual and families department. She was involved in the 2018 and 2021 federal court appeals on stateless and adopted children. Our second speaker is Eric, who is an associate with our dispute resolution and Individuals and Families Department. He was also involved with Ms. Jasmine Wong in the 2018 and 2021 Federal Court appeals on stateless and adopted children. If any of the participants would like to ask questions, please post your questions in the Q&A chat box, which you can find at the bottom of the screen. You can also upvote or like the questions, which are similar to your questions, and the most liked or popular questions will be discussed and answered by the speakers during the Q&A session at the end of this talk. The talk points which our speakers will be discussing are the relevant provisions in the Federal Constitution, arguments for gender equality for citizenship, conflicting High Court decisions, and pending appeals and possible outcomes. I now hand the screen over to our Ms. Jasmine Wong. Jasmine, over to you.
Thank you so much, Rachel. Welcome, everyone. Thank you so much for spending your afternoon here with us today. Now, recently there have been many discussions and news in the media about citizenship. And before we zoom into today's discussion, let's look at what our federal constitution has to say about citizenship. Just give me a moment and I'll share my screen. Okay, now the provisions in our federal constitution can be seen here. We will be looking at few different provisions where, as you can see at the bottom below, there are section 1 with several subparagraphs. Section 1 sub A, sub B, C, D, and E. The second schedule of our federal constitution says that if a person is born within Malaysia, within the federation, and under section 1 sub A, one of your parents is a Malaysian citizen, then you will automatically be a Malaysian citizen. And under the category of born within Malaysia as well, if you can show that you were born in Malaysia and you are not born a citizen of any other country, that you have not acquired citizenship of any other country within 1 year, then pursuant to the clause in the Constitution, you will automatically be a citizen as well. There are few other provisions which talk about individuals who are born outside of Malaysia. And this is where we will be focusing on today, section 1 sub B, which says that if you are born outside of Malaysia and your father is a Malaysian citizen at the time of your birth, you will automatically be a Malaysian citizen. Section 1 sub C has a similar provision with section 1 sub B because it refers to the father as well. And again, if you can show that your father is a Malaysian citizen when you were born outside overseas, then you will automatically be a Malaysian citizen provided you fulfill several conditions in the federal constitution. Moving on to section 1 sub D, this is specifically pertaining to birth within Singapore. So in Singapore as well, if you are born in Singapore and one of your parents is a Malaysian citizen, by virtue of this provision, you will automatically be a Malaysian citizen. So as I've mentioned earlier, today we will be focusing only on section 1 sub B, where if you are born outside of Malaysia and your father is a Malaysian citizen, automatically you will be a Malaysian citizen. So this is the entire provision of section 1 sub B, which we have seen earlier. Recently, the news talk about the arguments on gender equality for citizenship because, as we can see from the provision, it refers solely to the father. But what happens if you are born overseas and your mother is a Malaysian citizen and the father is not a Malaysian? The arguments of gender equality is not a new argument because we have various international conventions on this. For example, if we look into Convention on the Elimination of All Forms of Discrimination Against Women, well, in short, this is called CEDAW. Article 9 sub 2 says that state parties shall grant women the equal rights as men with respect to the nationality of their children. And similarly, in another convention, Convention on the Rights of the Child, commonly known as the CRC, Article 7 says that a child shall have the right to acquire nationality. So, going with these two conventions, by right, if you are born overseas and you can show that, there shouldn't be any discrimination between mother or father. As long as one of them is a Malaysian citizen, by right, the child should be automatically a Malaysian citizen. And we have that similar provision in our federal constitution as well. Article 8 says that, look, first of all persons are equal before the law. And second, there shall be no discrimination against citizens on the grounds of religion, race, descent, place of birth, or gender. So we can see that the federal constitution protects discrimination on the grounds of gender. And by way of a little bit history, the word gender was initially not in Article 8 sub 2. It was only incorporated into the federal constitution back in 2001. And the reason for this is because Malaysia wants to be in line with their obligation under CEDAW. And we have various cases where the court actually say that the intention behind the incorporation of the word gender in Article 8 sub 2 is to reflect the view that women are not discriminated against. So we have a lot of cases, again, which talk about discrimination. But for the purposes of today's talk, I have selected this particular quote from the very recent case of CTEB 2021 in the federal court. Our Chief Justice of Malaysia, Yang Ahmad Arif Tengku Maimun, she said this: the discrimination between the father and mother is expressly in violation of Article 8 sub 2 of the Federal Constitution, because Article 8 sub 2 provides that there shall be no discrimination against citizens on the grounds of gender in any law. And the reason why I chose this particular quote is because the case of CTEB concerns citizenship as well. Although this quote from the Chief Justice is in the minority judgment, it is not the majority's judgment in that case. But the quote is definitely on point on this, because if we look into the federal constitution, there is no reason why a child should be discriminated against just because of the father or mother's identity or citizenship status. And so how do the High Court actually interpret and apply the principle of gender equality in our cases, especially concerning citizenship cases? We will now demonstrate that there are actually conflicting High Court decisions. And I will let my colleague Eric explain further. Over to you, Eric.
Thank you very much, Jasmine. Now share my slides on this topic on conflicting High Court decisions. Okay, right. So as Jasmine mentioned, we do have a couple of High Court cases that are conflicting. One of it was handled by us, our firm, which is the MSAM case. And the other one is the Family Frontiers case, which I think a lot of you may have read or heard about in the news. So what are the differences? Why are we saying that they are conflicting? So I'll go to MSAM first. So in MSAM, so the facts are like this. Briefly, the plaintiff was born in India to a Malaysian mother and an Indian father. And the parents were married at the time of her birth. The plaintiff also has two other siblings who were subsequently born in Malaysia, and actually they are Malaysians as compared to the plaintiff, who is a non-Malaysian. And due to her status as a non-citizen, her son, who was born in Malaysia, was also deemed to be a non-citizen or recognized as a non-citizen. So we went to court. We sought for a few orders, as shown on the screen. For example, we wanted a declaration that the plaintiff is a citizen of Malaysia by virtue of her mother's citizenship, a declaration that father, in Section 1B, the word father, in Section 1B, as explained by Jasmine earlier, it should be interpreted to mean either parent, that is father or mother. A declaration that the government's failure, refusal, or omission to recognize the plaintiff as a citizen of Malaysia contravenes Article 8 of the Federal Constitution, which prohibits discrimination against gender, as again explained by Jasmine earlier, and an order that the government issues a certificate of confirmation of citizenship and my card to the plaintiff. So after submissions, I just go straight to the grounds that of judgment by the court. So the court actually disagreed with us and the plaintiff, and why she did so. So for example, she said that the plaintiff's contention that the word father should be interpreted to mean either parent is unsustainable. The ladyship felt that if the drafters of the Constitution intended to refer to either the father or the mother in Section 1B, the drafters of the Constitution back then would have used the phrase, whose parents one at least. And this phrase is actually used in A and 1D of the same schedule of the Federal Constitution. Yes, and I'll show on screen here. So there's a comparison. So A and D has the phrase, whose parents one at least. B and C, which is the important provisions that we're talking about today, states father. So because of this, the High Court held that there is a difference, and because there's a difference, it clearly shows that the word father specifically refers to only the father and should not be construed to mean either father or mother. So another argument that we also raised was that under the Constitution, there is a provision, the 11th schedule, that says that words importing a masculine gender would include females. And therefore, by virtue of that provision, the word father should include mother. The High Court also disagreed, and because her leadership felt that, or opined that, the words importing masculine gender are like he, him, his. And so those words can be used to mean she or her, respectively. And the High Court felt that the word father is not merely a word importing a masculine gender, but specifically refers to a male parent. And again, she reiterated that if the drafters of the Constitution wanted or intended the word to mean father and mother, then they would have used the phrase parents one at least. Because if not, then that phrase would be superfluous, because they did not need to use that phrase at all. An important thing I would like to highlight for MSAM's case was that there was actually no mention of Article 8 of the Federal Constitution in the grounds of judgment. And this is important, as I will show on why this no mention of this Article 8 is important. It's a factor that is different between MSAM and the Family Frontiers case. So I'll come to Family Frontiers. So briefly, Family Frontiers case was in December 2020. The Family Frontiers and 6 other Malaysian mothers filed a suit against the Malaysian government. And it was to challenge the operation of citizenship provisions in the Federal Constitution. The effect of these provisions is actually that the children born overseas to Malaysian mothers are being discriminated against by government in not registering these children as Malaysians. So these are the orders sought in that case: a declaration that Section 1B is in violation of Article 8, a declaration of Section 1C is also in violation, declaration that 1B and 1C should be read harmoniously with Article 8 so as to include the mother of a child born outside of Malaysia, declaration that the mother of a child born outside of Malaysia has a legitimate expectation that the government would abide by its international obligations under CEDAW and interpret the sections according to CEDAW and CRC, and of course the consequential orders to order all the government departments to issue documents relating to citizenship. So in this case, the judge had a different view of the provisions and how it interacts with each other. So the High Court in this case held that the impugned provision, which is Section 1B and C, must reflect the provision of equality before the law and equal protection of the law as provided for under Article 8 of the Constitution. And His Lordship held that there is a cogent reason why it must be reflective of Article 8, because Article 8 falls under fundamental liberties. There's a particular section in the beginning of the Constitution that talks about fundamental liberties. And His Lordship held that the principle of fundamental liberties are based on universal norms that transcend any law. And non-compliance with these fundamental liberties will lead to anarchy and dissatisfaction among members of society. So His Lordship actually placed these fundamental liberty provisions quite highly. And he went on further to say that in the Malaysian context, not only these norms have been adopted in the Federal Constitution, but they have been given a higher pedestal than all other provisions. And as I mentioned, it's because that these provisions have been placed at the very beginning of the Constitution before all other provisions. So any breach to these fundamental liberties should be viewed restrictively. And the High Court went on to say that if you look at the extract of the Hansard, which is the record of the debates in the Parliament, there is nothing to show that there was a conscious effort to discriminate between mother and father in granting citizenship. So the focus actually was whether citizenship should be given to or not given to children born out of Malaysia. So it's not about whether a father or mother should be able to pass down their citizenship to their children. And furthermore, during the course of the case, the court actually directed the defendants, the government, to justify the discrimination. But the defendants failed to provide any justification whatsoever. And so it was assumed that it's safe to assume that there was no justification for this discrimination. So as a result of all this, the High Court actually allowed the application and basically held that mothers of children born overseas should also be able to pass down their Malaysian citizenship to children who are born overseas. So therein lies the distinction, and between the MSAM case and the Family Frontiers case, because one says no, father cannot be equal to mother in terms of passing down citizenship. In terms of when you want to interpret the words, father cannot be also mean mother. But Family Frontiers say yes, father can be equal to mother as well. And I mentioned earlier that there's a big, important difference between the case of MSAM and Family Frontiers is because Article 8 was not mentioned in the grounds of judgment, but it can be seen in the case of Family Frontiers. The High Court judge actually placed a lot of emphasis on discrimination and how the fundamental liberty should not be breached or should be protected. Hence, His Lordship came to that decision. So we have this conflicting decisions. So how do we resolve it moving forward? And what has been done by the parties to resolve this issue? Now I'll pass it back to Jasmine to explain what is going on at the moment. Over to you, Jasmine.
Thank you, Eric. Yes, exactly. What is going on at the moment? Because on one hand, we have the High Court in Family Frontiers case who upheld the principle of gender equality and took the position that this particular provision of Section 1 sub B, which uses the word father, is discriminatory, and that the discrimination is apparent. And we have, on the other hand, another case in the MSAM decision, which says that father means a male parent. So yes, what is next? Because as of now, in MSAM, the plaintiff has already filed the appeal against that unfavorable High Court decision. And the matter is now pending in the Court of Appeal. And similarly, in the Family Frontiers case, where the mothers actually got the declaration, and by right, pursuant to the High Court order, the children will automatically be Malaysian citizens moving forward. But what the government actually did is they appealed against that favorable decision, and at the same time they also applied to postpone. Well, the word is stay, but it means to postpone the execution of the judgment, meaning to say that, for example, JPN, who is supposed to issue my kid or my card to the affected children, are told to put on hold first because there is now an appeal pending in the Court of Appeal. So as of now, both matters, because they concern the similar provisions in the Federal Constitution, it concerns the same issues and a very similar situation as well. Both cases will actually be heard together in the Court of Appeal. And now we are already in November. So tentatively, it will be heard sometime in the first quarter of 2022. But as of now, we do not have a fixed hearing date yet. So what are the possible outcomes actually? If during the hearing in the Court of Appeal, and Court of Appeal take the position that, look, there is an apparent discrimination and we need to uphold the principle of gender equality, and we direct that, for example, the JPN are to recognize these children as Malaysian citizens. What happens if in that situation is that it is likely for the government to appeal to the federal court as well. And on the other hand, if the Court of Appeal say that, look, if Section 1 sub B uses the word father, which is a very specific word as opposed to, the phrase whose parents want at least, which indicate that you could at least refer to either the father or the mother. Now, if the Court of Appeal took a restrictive position, similarly, the mother in Family Frontier's case and the plaintiff in MSAM will have the recourse to appeal to the federal court as well. And legally, it is not so easy to appeal to the federal court because we will need to show that there is a novel constitutional issue, that this is an issue to be heard for the first time by the federal court. And such a case is very important and to the public advantage, which if any person were to look into these two cases, it is likely there are chances that these three elements will be satisfied. Another possible outcome is that there is an amendment to the Federal Constitution. So the government may remove the word father and replace it with parents one at least, as we have seen in Section 1 sub A and Section 1 sub D of the Federal Constitution. But it is not so easy to just amend the Federal Constitution, because what do we need? We need the consent of the Conference of Rulers. And once that consent is obtained, we will need to present the amendment bill to the Parliament and get a two-third majority for the amendment to be passed. And this is exactly what was reported in the news, because our Home Minister has informed the Dewan Rakyat that the government is planning to amend the Federal Constitution after being informed of these two particular conflicting High Court decisions. The hope, or rather the intention of the amendment behind this constitution is that Malaysian mothers will be able to pass down their citizenship to their children who are born overseas. So this is the very latest update, which was in September, and I think we will all be holding our breath to see what comes next. Thank you. We will now move on to questions.
Thank you, Jasmine and Eric, for your presentation and your insights. We will now move on to the Q&A session. So to all participants, if you have any questions, please post them in the Q&A chat box, which you can find either at the bottom or at the top of your screen. Jasmine and Eric, currently we only have one question. So the first question is from Min Sang Chen. So the question is, what if the child was born out of wedlock overseas? Subsequently, the parents married in Malaysia. Can the child apply to be a Malaysian citizen? Jasmine, would you like to take this one?
Yes, thank you, Rachel. Well, we do actually need a little bit information on this, because what if the child was born out of wedlock overseas? There are two possible answers to this. If the child is born to a Malaysian mother out of wedlock overseas, it is possible to register the child as a Malaysian citizen following the mother's citizenship status. But if you are referring to the child who is born out of wedlock to a Malaysian father and taking the position, the latest decision from the Federal Court in CTEB, the current position would be that the child's citizenship status will also follow the mother, who in that particular case is a non-citizen. So there will be a different process to try and get citizenship for the child. It really depends on which mother or father is a Malaysian citizen in this particular case, in this particular scenario.
Thank you, Jasmine. We also have another question. Yes, Eric. Go.
Sorry, Rachel. Yeah, I just wanted to just add a bit. So I think there is some sort of a interesting position if from the findings of CTEB, because what happens now is that if you are a Malaysian mother and you give birth to someone, your child overseas, and if you want your child to be a Malaysian subsequently, well, the results of that case is that you better not get married before giving birth, because under the current laws, if your spouse is a foreigner and you get married, overseas, means your child will follow your spouse's citizenship. However, if you were not married and you gave birth overseas, then your child will actually acquire Malaysian citizenship based on the findings of CTEB. So that is a quirk in the law that I think maybe needs to be addressed in the future. Yeah, that's all. Back to you, Rachel.
Thank you, Eric. Thank you, Jasmine. We also have another question in the chat box. Oh, sorry. We will just address the questions in the Q&A. Mr. Nasim, please direct your questions to the Q&A box, please. So we have one question from an anonymous attendee. Is the Home Minister accurate in stating that he is at risk of contempt of court if he had proceeded without appealing against the decision of the KL High Court in the Family Frontiers case? Jasmine or Eric?
Yeah, I'll take that. Yes, because there is already a court order directing a government authority to do a particular act. So it doesn't have to be specifically in this situation, but in any general situation as well, as long as there is a court order directing a particular individual or party to do to act in a certain manner, and the person deliberately refuses to comply with the court order, that would itself amount to contempt of court order already.
Thank you, Jasmine. Our next question is from Mei Lim. So her question is, in both cases, did the parents register the birth of their children with the Malaysian embassy immediately? Eric, would you like to take this one?
This one, to be frank, off the top of my head, I cannot recall the whether they did so. Jasmine, do you have any recollection of whether that is the case?
No, I could not recall at the top of my head.
But I think the important point is that it depends really on the citizenship of the parents, and also whether whether they were married at the time of birth. I think those will be determinative of whether the child actually gets Malaysian citizenship or not. Whether the parents did register their birth, it's I would say it's a more minor issue in the grand scheme of things. The more pertinent points are where the citizenship of the parents and the status of their marriage at the time of the child's birth.
Thank you, Jasmine and Eric. Our next question is from Mr. Nasim. So how might the constitution be changed? What is required to change it? Jasmine, would you like to take this one?
Yes. As was actually shown in the previous slide earlier, there are actually several requirements to amend the constitution. Some of it you only require a simple majority, 1/3, to amend a particular provision. But when we are talking about Section 1 sub B, which is in the second schedule of the Constitution, for that particular provision, we actually require a two-third majority in Parliament. And sorry, before we even get to Parliament, we would first need to get the consent of the Conference of Rulers first. So if they agree that this is an issue which it should be amended in the Constitution, they provide their consent, and only then the amendment bill would be passed in, not to say passed, will be debated in the Parliament, get that two-third majority, and then the amendment can be reflected in the Constitution. So two-third majority, that's the key in here.
Thank you, Jasmine. We have another question from Pauline. So Pauline is wondering, assuming the court rules in favor of granting a child born to a Malaysian mother citizenship, will the Malaysian mother need to reapply for citizenship for the child? So in her case, the mother had already applied to the Malaysian immigration in Australia 4 years ago, but no response has been received from the authorities. Eric, would you like to take this one?
Yes. So, I mean, maybe we need to get further information on what was the application made to Malaysian immigration in Australia. But I would say that once the courts have said, okay, Malaysian child born overseas is entitled to citizenship. If you had already applied for the citizenship, then I would think that it should be allowed, or whatever application you have made should be approved. Or alternatively, if you have not applied, then administratively, I think you just need to apply and say, look, this is the court's decision. I now please issue the relevant documents for citizenship to my child.
Thank you, Eric. Pauline also says thank you, Eric. So we have another question from an anonymous attendee. Anonymous attendee thanks you for the answer, Jasmine, and he or she has a follow-up question from the contempt of court question. So how likely is it that a committal proceeding will be filed if there had been no appeal?
Well, this would be upon the instructions of the plaintiff in the particular case. I would say 50-50. If there are no instructions to file for contempt, then no contempt application will be filed.
Thank you, Jasmine. We have another question. So from an anonymous attendee as well. So if the father of a child is Malaysian, but the mother is Cambodian, but both parents has disappeared and have left no clear documents. So the child is now in the care of the grandparents and uncle without any documents and citizenship. What would our advice be and how to go about to get her citizenship, or how to help the uncle to adopt the child? Eric, would you like to take this one?
Yes, thank you, anonymous attendee. So this is actually a multi-layered question, because you are starting from adoption, birth, adoption, and then citizenship. So I'll just go step by step. So so how you can adopt the child currently. So you say you have no documents. So importantly, you need to get a birth certificate issued. Assuming you have not had birth certificate issued, you need to get that issued before an adoption process can even be commenced. And in the adoption process, then you will need to show that the father and mother have disappeared. And if you can indeed prove that is the case, then you can apply for dispensation from the court to dispense with the consent of the parents. Because under the adoption laws, either the mother's consent is required, or if the mother and father were married at the time of the child's birth, both the parents' consent would be required for an adoption. So if you can get through all these hurdles, you can prove that you are suitable and capable to adopt the child, then you will get your adoption certificate, adoption granted, and you'll get a fresh birth certificate issued. And then the next issue will be whether spent other her birth, and also whether the child was actually born in Malaysia or outside of.
I apologize to anonymous attendee. It seems that Eric might be having some connection difficulties. We will get back to the answer of your question after Eric comes back with us. So I will just move on to the next question. And also a reminder for all participants to ask questions which are related to the topic of our webinar today. Eric, would you be comfortable to proceed with the remaining of your answer?
Yes, apologies everyone. There was some problem with my internet. I think that's why we need that 5G that our minister is talking about. We need to get it up quickly because these things happen. Yes, where was I? I was talking about the marital status, right? And how that would affect the child's citizenship. So I was saying, if the child was born in Malaysia and the parents were married at the time of birth, and if you can prove so, then you can say, then we'll look at who is the mother's citizenship. And the mother is Cambodian in this case, so the child's citizenship will follow mother's citizenship. Sorry, if the child, in this case, if they're married, then it will be either the father or the mother, so can be a Malaysian. But if they were not married, then the child will follow the Cambodian citizenship. And likewise, if the child was born overseas, then if they were married, then the child's citizenship will follow the father. And so the child will be Malaysian. But if they were, yes, so that will be the case.
Thank you, Eric. Our next question is from Kaying. So Kaying is asking, assuming the couple is not married and the father is a Malaysian, what could the couple do if the non-Malaysian mother with an expired passport gave birth to a child in Malaysia? Eric, I think you're more suited to answer this question.
Sorry, let me have a look at the question again. So assuming the couple is not married and the father is a Malaysian, what could a couple do if the non-Malaysian mother with an expired passport give birth to a child in Malaysia? Well, it depends on what I hard to say what you're trying to say that what could the couple do. But if you're talking about just in terms of citizenship matters, then it will again depending on. Okay, so you're saying that it's non-Malaysian mother, so the child's citizenship would follow the non-Malaysian mother's citizenship. Yeah.
Thank you, Eric.
Now, Rachel, before just to add to that, I think generally the first step in that kind of situation is to register the child's birth at JPN first. Go and get the birth certificate for the child.
Yes. Right.
And in that situation, if the parents were not married, it is still possible to include the father's name into the birth certificate, provided both the parents are present at JPN during the registration. But yes, first of all, get the birth certificate.
Thank you, Jasmine. Thank you, Eric. Our next question is from an anonymous attendee. So can kids born overseas to a Malaysian mother get Malaysian citizenship? Jasmine?
It is not an automatic process, as we have shown from our discussion earlier. It's not an automatic process. The journey will be long, will be tough. And right now, given the current state of law that we have conflicting decisions. So if you ask me, the short answer, especially if the mother is married, the short answer is no.
Thank you, Jasmine. Our next question is the opposite of the question which Jasmine just answered. So is Malaysian citizenship assured for a Malaysian mother and a foreign father if the child is born in Malaysia? Eric, would you like to take this one?
Yeah. Well, I guess nothing in life is 100% assured, but I think in this situation, I would say yes, is as assured as can be under our current laws. For a child who has a Malaysian mother and born in Malaysia to have Malaysian citizenship.
Thank you, Eric. There are no further questions from our participants, so I will conclude today's Q&A sessions. Thank you all participants for posing your questions to the panel. So before I forget, I have a few announcements to make. So please join us for our upcoming talks. As you can see, our talk schedule, our talks are every 2 weeks on Wednesday. So our next talk is on the 24th of November, which will be presented by Raymond Ma and Sebastian Liu. And the topic will be on rescue mechanisms for financially distressed companies facing liquidation. So if you would like to sign up for more talks, kindly scan the QR code on the slide. So secondly, please also fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat box. Thirdly, do follow or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Fourthly, if you would like to speak to our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference, such as Zoom or Google Meet. Please fill in the form on our website. The link is also posted in the chat box, or you can scan the QR code, which is on the screen. Finally, to our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.